The statement "no particular number of witnesses shall in any case be required for the proof of any fact" is one of the most important principles of the Bharatiya Sakshya Adhiniyam 2023, earlier Section 134 of the Indian Evidence Act 1872. It means that the law does not prescribe any fixed number of witnesses to prove a fact in a court of law. A fact may be proved by one reliable witness or may fail even if many witnesses are produced. Thus, quality of evidence is more important than quantity of evidence, meaning of the principle the law does not say that 2, 5 or 10 witnesses are necessary to prove a fact. The court decides a case by examining the truthfulness, reliability and credibility of the witness and not by counting how many witnesses have appeared. Example, if a person alone sees a road accident and honestly tells the court exactly what happened, his evidence may be enough to prove the accident. On the other hand, if 5 witnesses give contradictory or false statements, the court may reject all of them. Why does the law follow this rule? The law follows this principle because many incidents happen in the presence of only one person. Honest evidence should not be rejected merely because only one witness is available. A large number of witnesses does not always mean truthful evidence. The main purpose of the court is to discover the truth, not to count witnesses. Therefore, the quality, consistency and reliability of evidence are more important than the number of witnesses. Importance of the credibility of a witness. Before relying on a witness, the court considers whether the witness actually saw or heard the incident, whether the statement is natural and consistent, whether there are contradictions, whether the witness has any personal interest or bias, whether the statement is supported by other evidence, if available. If the witness is trustworthy, even a single witness can prove the case. Is one witness sufficient? Yes. A conviction or a civil decision may be based on the testimony of a single reliable witness if the court is fully satisfied about its truthfulness. However, if the witness appears doubtful or unreliable, the court may require additional evidence before accepting the statement. Thus, the law neither insists upon multiple witnesses nor blindly accepts a single witness. Everything depends on the facts of each case. Situations where corroboration may be desirable. Although one witness may be sufficient, courts sometimes look for supporting evidence in cases involving accomplice evidence, child witnesses where circumstances require caution, identification by a stranger, cases involving doubtful or weak testimony. This is a rule of prudence and not a compulsory rule in every case. Case study, Vadivelu Tevar v. State of Madras, 1957. In this famous case, the Supreme Court explained that witnesses can broadly be divided into 3 categories. Wholly reliable, the court can safely base its decision on such testimony even if there is only one witness. Wholly unreliable, the court should reject such evidence. Neither wholly reliable nor wholly unreliable, the court should look for corroboration before relying upon it. The court held that there is no legal requirement that a certain number of witnesses must be examined. The reliability of the witness is the real test. Simple understanding: if one witness is completely truthful and trustworthy, his evidence alone may be enough for conviction. If the witness is doubtful, the court will seek additional support. Conclusion: the principle that no particular number of witnesses is required to prove any fact means that the law values the quality of evidence over the quantity of evidence. A single trustworthy witness may be sufficient to prove a fact, while several unreliable witnesses may fail to establish it. Therefore, the court always examines the credibility, consistency and reliability